progressive.
All right, recording is in progress, and we are live on YouTube.
I don't know who opens the meeting or.
That would be Mr. Plumley. He is our vice chair.
I just open the first meeting, the training session, and
It's 10:09. I call this meeting to order at 10:09.
so I need to go over there.
That's what you need to say, Mr.
Get
Plumley.
this on.
All you need to do is just say you call the meeting to order, and it's 10:09.
We call it meeting to order and it's 10:09 a.m.
Oh,
So, yeah.
well, good morning. Good
Good morning.
And for purposes of the record and for anybody participating online, we only have 3 members here at this time, which allows us to open the meeting and have this training. It would not otherwise allow us to take any action or hear an appeal or request for relief that you're normally accustomed to hearing from members of the public. They're aggrieved by some decision of the city or just want some relief. So we can move forward with this real quick training session. I don't know if y'all remember me. My name's David Olson. I'm the city attorney with Olson & Olson. My nose is still clogged up, so it sounds like I'm talking through an air filter, but the wind never stays in one direction around here for very long, does it? Okay, so this is a real quick kind of refresher course. I just want y'all to be aware of your responsibilities. Talk about, when I say legal issues, and really the only pertinent legal issue for us to discuss tonight is what are considered appropriate grounds for considering a variance request. And we'll get into that. In the last legislative session, the state legislature did add 5 bullet points, which kind of outline, okay, these are the categories of things that you can consider when looking at whether there's an undue hardship for purposes of the variance. And then we can answer questions if we have time. And it looks like we might run a little over if our 4th member, for purposes of having the 2nd meeting, may be running a little late. So we'll do the best we can. Okay, overview. I really just put this up to kind of hammer the point home that the difference between the zoning commission and the zoning board of adjustment. So a zoning commission looks at potential changes. They can initiate themselves. More often it's issues come up with the city council, citizens complain about things, or we see a lot of different issues that arise. And sometimes that starts with you guys, meaning if you start to see the same request over and over in a particular area, then we at the staff level look at that and say, okay, maybe we need to make a change. And we initiate that change legislatively through the zoning commission, where they make a recommendation, then the council makes that change. And I just want y'all to be aware of that, because your function is not to legislate, meaning we may look at a rule and say, this doesn't make sense, this isn't fair, we're going to grant relief because we don't agree with it. Well, that's not appropriate. The standard review is reasonableness. So a court's going to look at your decision and say, did they abuse their discretion when making this determination? That's a pretty high standard. So to overturn a decision that you make is going to require the other side, whoever's contesting that decision, to show that you abuse your discretion. Well, one way to do that is say that you are legislating and not actually adjudicating, which is, y'all are kind of a quasi-judicial bunch. You're essentially a panel of judges that get to make a decision. It's only appealable to a higher court. It's not appealable to council. It's not appealable to staff. It can go to district, county court, or county court of law. So I just don't want y'all to think, if you disagree with something, it is perfectly reasonable for y'all collectively we would like to make a motion to have council take a look at this issue because we think there's something worth looking at. It's not to take that into consideration when granting relief. I think that makes sense to everybody. So zoning board of adjustment, really you do 2 things. Do y'all have special exceptions, Angela? I don't even remember if y'all have special exceptions. I don't think you do.
I don't know.
Special exceptions are essentially the same thing as a variance, except you have certain qualifiers, meaning if you meet A, B, C, and D, then we can consider a special exception. It's qualified variances. I don't think y'all do. If it comes up, we'll deal with it at that time. For now, you're really looking at If somebody comes in, asks for something, and the zoning administrator, I think, and this is probably your building official, you do that? Okay.
Yeah, I handle the.
Say, no, that violates our zoning ordinance, we're not gonna do that. Well, they can challenge that interpretation. Come to you guys and say, we don't agree with the zoning official. We think it means this, and here's why. And y'all can decide whether you agree or not. You also, which is more customary, hear variance requests. People that say, okay, I can't, if I adhere to the rules, I'm not gonna be able to use my property like I should reasonably be able to use it. It essentially deprives me of a property interest. We'll get to that standard a little more too.
And they also do the substandard.
I'm not gonna get into substandard. Next time we have a substandard something come up, because that's a different hat that you're wearing. And you'll see that one of the things you can do is hear things at council. As an appellate board, council may give you additional duties, but it's really not as a zoning board of adjustment. You're just the same group of guys that wear different hats. So the next time a building standards issue comes up, we may do a quick refresher before that too. If nothing else, it looks good if somebody appeals it to a court, but we've taken the time to at least go through the process and understand the rules as it relates to giving relief. So y'all have 5 members, 3 are only present right now, but it takes 75% of the members to hear not only evidence related to a case, but to make a decision. So with just 3 here today, we couldn't do anything as far as grant relief or even hear a matter. If somebody comes up and says, I'd like you to hear my case, we have to have at least 4, 75% here. 2 alternates, which are supposed to fill in when they can. And I recognize that it's been challenging to get all 5 members here. It's something we're going to talk to council about to try to maybe bring in some other individuals that maybe could fill in more timely. And that way you have all 5 members here at any given time. So role of ZBOA. So that's error in zoning decision. That's what we talked about earlier, where the zoning official makes a determination about it in the interpretation of a particular rule and somebody doesn't agree. Special exceptions we touched briefly on, y'all don't have, so really we're looking at variances. And we'll get into the standard of review as it relates to a variance request in a minute. And then the other matters authorized by council. If you think about it, council can delegate any kind of appellate, anything to you. It makes sense to grant that additional authority to the zoning board of adjustment because y'all are already, I guess, learned when it comes to the rules related to those types of appeals. And the same standard of review applies to Building Standards Commission as it does to Board of Adjustments and other appellate bodies. Errors. So this is pretty self-explanatory. Zoning official, zoning administrator makes a determination about what a rule means. They don't, the applicant doesn't agree, so they can bring that to you. And y'all can decide. You can do 3 things. You can uphold the determination, reverse it entirely, or modify it in part. Meaning you don't have to, it's not a all or nothing determination. You can decide that, okay, we don't agree 100%, however, we agree with most of it, but with these conditions. That is perfectly legitimate. Anybody that is aggrieved by a decision, and that means not only the person that we say no to, but also somebody that's within 200 feet, can appeal the decision of the zoning administrator. Variances. These are kind of the 3, I would compare it to almost the 10 commandments in Christianity. These are the 3 pillars of variance requests. It cannot be contrary to public interest. So first thing you're looking at is when somebody requests some relief under variance is, if we grant relief, is that going to do something that harms other people? Second, due to special conditions, enforcement of the ordinance will result in unnecessary hardship. I don't think there is a term in municipal law that has been litigated more than what constitutes an unnecessary hardship. Now, the statute has been amended by the infinite wisdom of our legislature as it relates to conditions. And we'll go over that in a minute, because I'm not 100% sure I know exactly what they're trying to accomplish. And none of that stuff has been litigated yet, so we really don't have any clarification from the courts. But y'all are familiar, you've done this enough now. When somebody says they have an undue hardship, we look at, if we literally enforce our rules, does it create some heartache, some pain for them, and what is that? And we'll get into what that means in a minute. And then the spirit of the ordinance is observed and substantial justice is done. I think y'all recognize that typically zoning ordinances are put together to protect certain groups. You don't want a coal, refinery right in the middle of a residential area. So we have residential districts. We keep only residential uses area to protect the people in there and give them some certainty that we're not going to have a commercial industrial use right next door that would affect not only the property value, but their quality of life, their ability to enjoy their property. So when you look at these things, you look at kind of the overall ordinance, what its intent is, and whether or not granting relief would in some way impact other people's ability to quietly enjoy their property. All right, this is where things get a little trickier. So the legislature added these 5 bullet points. Unnecessary hardship. So the board may consider the following grounds to determine if compliance with the ordinance would result in an unnecessary hardship. So first being financial cost of compliance is greater than 50% of the appraised value of the structure. I know that we have preached for years that you can't take just financial hardship in and of itself as grounds for granting a variance. Well, I guess the legislature didn't like that direction and changed it. So now we can look at the appraised value, and the burden still lies on the applicant to show this. That, hey, look, if you look at my Liberty County appraised value for my structure, it's $100,000. If I was to have to comply with this, or doing a remodel or something, and I lose over 50% of my appraised value to my house, then I would be entitled to relief as a matter of law. Those aren't going to come up as much as you would think, but it still gives the applicant the opportunity to, I guess, fashion their argument in that capacity. So keep in mind that financial hardship is now on the table, but you have to reduce by 50% the value of the structure to be legislatively entitled to that kind of relief. It does not preclude you, if it doesn't meet that threshold, from taking that into consideration and still granting some relief if you think it's appropriate, using those other 3 pillars kind of as your guiding force. Compliance would result in a loss to the lot of at least 25% of the area in which the development may physically occur. I do this for a living. I don't know what this means, because in fact, Angela and I were talking about this before the meeting. So if we have a rule in place that says setbacks is a great example. Here's our setbacks, you can use this bit of land for development. Well, that's the rule. That's what may physically occur. So I'm not sure what it means by 25% loss in the area, but we'll take that into consideration. The only thing I can think of is in the off chance that we have distinguished setbacks from corner lots or interior lots, or certain setbacks from easements, and this particular property would unduly be burdened by an additional setback. We can look at that rule and say, well, if you weren't adjacent to this particular use, you would be able to do it a certain way. So those are going to be on a case-by-case basis. I'm not sure that's applicable to anything y'all are dealing with today, but just be aware that if it does affect the ability of them to use a certain portion of their land, again, that a lot of that has to do with setback issues, height issues and setback issues, then we'll look at that rule in more depth. Compliance would prevent the structure from being in compliance with city ordinance, building codes, or other requirements. We're putting into writing what has always been the case, meaning and that's the whole purpose of a variance, of this appellate process, is if the literal enforcement of our rule precludes you from being able to build something reasonable in that area, that's why we have this process. So if somebody comes in and says, I have a very small lot, if I have to comply with your rules, I can't build something that's reasonable. Well, y'all can grant some relief in that instance. And then compliance would result in encroachment on adjacent property. The only encroachment I can think of there would be into these setback areas, the areas in which you can't build. But I'm not 100% sure what that means either. We haven't seen a case of first impression dealing with that issue yet in the courts. And structure is a non-conforming use. And we've always kind of taken that into consideration. Anytime we have a building that is otherwise non-compliant but has existed forever, then y'all can take that into consideration if they're asking to do certain remodeling or something or other things. A good example of that would be if you have a house that we have a 10-foot setback now, side yard setback, for just argument's sake. And at the time the house was built, we only had 5. So they're encroaching 5 feet into the side yard setback. And they essentially want to add on to the bathroom in the back and have that line up with that 5 yard. Y'all can take that into consideration, say it makes sense. You're not adding to the existing encroachment that already exists, and we'll allow you to go ahead and add that on and encroach into the setback. Does that make sense? So I'm getting a lot of blank stares. So. All right, decision. 4 votes, we already talked about that, requires a supermajority, 75%, for y'all to take any action, whether it's reverse, modify, or affirm the decision. I I think y'all recognize that you are quasi judicial, so you're a judge. We have to give proper notice. We have to identify the parties. We like to follow some procedural rules. If that's the statute, I would encourage y'all at some point to look at those procedural rules. Just FYI, Angela and I have identified not only this new portion of the act that has been added by the legislature, but it's going to necessitate a change to our city ordinance as well to identify the change in the law. So we're going to be updating your packets. As a part of that process, I'm going to look at your rules as well. I may update those a little bit anyways, but it's important for y'all to understand the rules. A lot of these issues are attacked on due process claims, that we weren't afforded the opportunity to speak, or we weren't given an opportunity to cross-examine witnesses, those kind of things. So I'd like to treat these almost like a civil court, if possible, as close as we can get to that, and adopt those same kind of rules. So recognize that, and we'll intervene at the staff level, that we want to give everybody every opportunity to exercise due process so that they can say what they have to say or respond to any comments that are contrary to their position. Ultimately, y'all deliberate and come up with a written decision. It's an order from the court, from you guys, which Angela puts together templates, but y'all can modify as you see fit. Appeals, just like I mentioned earlier, if somebody is aggrieved by a decision that is made at this level, they can't go to council and complain. They have to go to district court. So y'all are, it's no different than a separation of powers issue. Council is the legislative branch, they're Congress. Y'all are the Supreme Court. You're, for purposes of the city, y'all are the final say when it comes to these judicial actions as it relates to the zoning ordinance and the other stuff for your other hats. But for purposes of the zoning board of adjustment, we're just dealing with the zoning ordinance. So important to know that persons that are aggrieved, whether any taxpaying citizen in the city can allege they're aggrieved by your decision and file suit and appeal the decision. The city does. Doesn't happen very often, but you'd be surprised how many times we've had to recuse ourselves because the city council has decided to sue the zoning board of adjustment because they didn't like a decision they made. Now, this is just a real quick overview. We have a couple more minutes before the next meeting of other rules and laws that apply to y'all. This is all common sense stuff. Conflicts of interest, open meetings, open records. So check that, you can't see it, but it says chapter 171. So that's the conflict of interest chapter in the local government code that deals with, hey, I've got a conflict of interest. I need to file what we call a chapter 171 affidavit and abstain from participation in the meeting. Substantial interest in real property or business entity. So if you own real property or stand to benefit by a decision that y'all would make as it relates to an applicant's request, your neighbor wants some relief and it would actually appreciate the value of your property if he got the relief. A red flag should go up. If you're going to stand to gain by a decision that you make, then you need to let staff know so that we can have you fill out the proper paperwork and abstain from voting. And that's a special economic effect. This comes up more often than you would think. And for instance, when council approves a huge drainage project and y'all stand to gain because your drainage in front of your house is going to be improved. Well, so does everybody else in the city. So you don't have a special economic effect. The same thing applies to requests coming from applicants as it relates to zoning board adjustment. If you're going to receive a special economic benefit, whether it's appreciation in the value of your property or additional ingress, egress, anything that you think is going to help your property out, red flag, let us know, and we'll make sure that you sign the appropriate affidavit. When it says abstain from participation, really what we would suggest you do, and this is why we have alternates, is just stay home, so you wouldn't have to come, if that was the case, but you just let us know. Again, public servant laws, these are penal code violations, bribery, undue influence, those kind of things. So if you avoid receiving any gifts or anything, if somebody is seeking relief from this board and they call you and say, hey, look, you want to go watch the Astros World Series game? Great. Red flag. So again, this is all pretty common sense type of stuff. We don't want anybody giving you anything or talking to you beforehand that would unduly influence your decision. For instance, you mentioned you kind of drove by. We try to keep everything, all evidence within the bounds of this, but it's not uncommon for people to drive by to see kind of what we're talking about. If the property owner had stopped you and said, hey, come on inside, let me cook you some breakfast. red flag. Sorry, I can't do that. You know, as good as a breakfast may be, please don't. Open Meetings Act, I think y'all are all aware that we have to post this 72 hours in advance, and give the public the opportunity to not participate. Well, I guess they can't participate now. They get to speak, they get to observe as well, and that's online and in person. We take care of all the statutory requirements, but just recognize that even if an emergency arises, we still have to post 72 hours. We have to give proper notice, all those kind of things. Have they all taken their open meetings training? Have you all at one point or another taken any open meetings training? It'll be the best hour of your life. So Jennifer's going to help set everybody up and make sure they have certificates. It's an hour. The Attorney General has a hour-long kind of just go through it. There's a certificate you print out at the end of the day. If you haven't done it yet, I would encourage you to do it.
It's been here for a while, so I don't know if they have or not.
If we have a certificate on record, that's good enough for me. You don't have to do it every time, unless you take some time off and then come back. We already went through this Open Meetings Act stuff. Just recognize that if y'all talk about this outside of an open meeting or amongst each other or with other people, then technically it could result in a criminal prosecution. Now in Liberty County, I don't know if that's going to happen, but just recognize that's the case. Have y'all ever heard of walking quorums? I mean, this is very common, especially in small towns. Meaning the law essentially says you can't meet in numbers of a quorum to talk about an issue, because then you have an illegal meeting. It wasn't posted properly. However, it also precludes you from talking one-on-one, and then, okay, I'm going to go over to talk to you about this issue. You're essentially circumventing the act by dealing with individual board members one at a time, just kind of working your way down the line. That is also unlawful, so please avoid that as well. And that, nowadays, that used to be huddling up. The old kind of cornerstone case in this is the commissioner's court at the county level, where two commissioners were in the restroom together and having a conversation. And there just happened to be an applicant that was in a stall and overheard the conversation. And the courts struck it down. In fact, those two people were prosecuted. I think even spent like a week in county jail. Nowadays, it's all electronic. It's not necessarily talking around the water cooler. It's you text, you email, social media, it doesn't matter. Just don't talk to each other, even if it's just posting something. If you do that kind of stuff and other members of the board happen to be able to see your post, that still constitutes a deliberation, unlawful deliberation. So the Scott Bounds in our office has this kind of, keep it in the room, on the agenda, and within your scope, meaning you're only dealing with zoning board of adjustment issues. Stick to what's on the agenda and only talk about it when we're in the meeting, and then you'll be safe. Public information, I just want you to recognize that anything that you write, anything that you say, even a voicemail that you receive, is technically considered public information. So if you happen to receive a text, an email, voicemail may be a little more difficult, but if something in writing that concerns you because it's dealing with public business, only one copy has to be kept. So forward a copy to Angela or Jennifer, and then you can delete it off your phone or your computer. And it does happen. Sometimes applicants will get the names of the board members ahead of time and try to lobby a little bit. So if you get that kind of stuff, just think, no, thank you. We'll talk about it during the meeting. And if you get any communication, forward it to Angela and delete it off your computer. Common sense stuff, reply all. You don't need to worry about keeping public records. If you get something that you think is a public record, just give it to Angela. And we have a retention schedule. The Texas State Library puts out a long list of how long we have to keep certain stuff. She knows how to do that, so just give it to her. Any questions? We're still missing a fourth, so if y'all have any questions about this, I'll be happy to entertain. Otherwise, what we're going to do is come up with our updates to your binders and make sure that y'all all get that for the next time. So no questions. Everybody's still awake. We still have a regular meeting, so got to keep the energy going a little bit. All right, so for purposes of the audience, we're still waiting on an additional member.
So we're going to go ahead and close.
Yeah, I think we'll close the first meeting, and then we're going to wait to open the second meeting until we get our fourth member. So, Mr. Chairman, you can go ahead and close the meeting.
The meeting is closed at 10:30.
close this meeting
You
at
talk to me. That's the purpose.
10:34.
You talking about?
We're waiting for Mr. Benedict
Yeah.
to show up.
We have a
So
crossover.
you don't have to do anything else.
Yes, there's no further.
Okay.
Okay.